Welcome to Washington Legal Foundation's webinar. My name is Glenn Lammy. I am Executive Director and Vice President for Legal Studies of Washington Legal Foundation. For those of you not familiar with the foundation, we are in our 49th year of free enterprise advocacy and education. We practice our mission using a variety of different tools, file amicus briefs in federal and state courts, comment on regulations, initiate administrative actions sometimes, put on programs such as this one, and also publish papers in a variety of formats, and possess a well-trafficked blog, the WF Legal Pulse. For those of you not familiar with us, I hope you spend some time on our website after the program. Included among the many legal issues that came to my attention this week were two that I think are really timely for today's webinar. One was Maryland's Supreme Court's rejection of tort claims against energy company BP that were filed by Baltimore, Annapolis, and Anne Arundel County. The other was a civil racketeering suit California's San Mateo County filed against 3M and DuPont over PFAS in firefighter gear. I guess I could probably conclude the social media addiction verdicts in New Mexico and Los Angeles in a way, because numerous copycat lawsuits have been filed by public school districts. These instances of cities, counties, and even school districts entering the regulation through litigation arena are not isolated. As you'll hear today, they are just the latest example in a growing trend of political subdivisions masquerading as states in court. These intrusions, our panelists will explain, should not be seen as more is better necessarily. WLF's published two working papers in the last 9 months on today's topic. The first last July by former Nebraska Attorney General Doug Peterson, and the second this past February by two of our panelists, which featured a foreword by Kansas Attorney General Chris Kobach. We continue that conversation today with this program. Let me introduce our panelists for the day. Joe Sciarrotta is Chief Deputy Attorney General for the state of Kansas. In that role, he serves as the Chief Advisor to Attorney General Kobach, providing strategic, legal, policy, and administrative counsel. He previously served for 7 years in the Office of the Attorney General of Arizona. Prior to that, Joe was General Counsel to the Governor of Arizona, an Arizona Superior Court Judge, and Vice President Legal of Meritage Homes. Rob McKenna is a partner in the Seattle, Washington, and Washington, D.C. offices of Orrick. He leads the State Attorneys General team in the firm's State and Federal Government Solutions Group. Prior to joining the firm, Rob served 2 terms as Attorney General of Washington from 2005 to 2013. While serving as AG, he served as President of the National Association of Attorneys General from 2011 to 2012. And most relevant to WLF, he's a member of our Legal Policy Advisory Board. Finally, Andy Cook, who's also a partner at the Washington, D.C. and Seattle, Washington offices of Orrick, is a former Chief Deputy Attorney General for the state of Wisconsin. So he has extensive experience representing businesses before state attorneys general involving investigations and lawsuits. I want to remind our audience that we are recording this webinar today. If you have any questions, please use the Q&A function in the Zoom webinar toolbar. So since we're going to be talking about the litigating authority of states as compared to their political subdivisions, how do states via their attorneys general get their authority to file lawsuits on states' behalf, Joe?
Well, in almost all states, only a state attorney general may bring a case that seeks to remedy an alleged injury related to fraud, health, safety, or public welfare as to the public at large. And most of this authority comes from statutes, but a lot of it also comes from our common law doctrines dating back to our English heritage back in the day. But fundamentally what this is, it's another aspect of the vital doctrine of separation of powers. When governments, political subdivisions, different branches, when they don't stay in their lane, the balance of power and the rule of law are eroded, often egregiously, as we're seeing in some of this litigation. And in turn, the well-ordered system is eroded as well. And we can argue litigation chaos ensues. The common law doctrine for state attorneys generals to bring actions on behalf of a state comes from the doctrine known as parens patriae. It's Latin for parent of the country. When attorneys general throughout history had inherent authority to represent the state interest and to adjudicate it, and that has been brought down over the generations, and it's long been recognized ultimately by our own United States Supreme Court. And in part, this was the authority that attorneys general used to pursue tobacco litigation in the 1990s. So there's a fundamental difference as to where state AGs get their authority from specific statutory authorization from the common law compared to political subdivisions like cities and counties, because the cities and counties are not themselves sovereign in our constitutional system. They are creations of the state, and case law has held that they don't possess parens patriae authority. And that's a key distinction, because often there's, I think, a misnomer when there's a comparison between states and the federal government and political subdivisions and states. We forget, now we're getting into our 250th history of this great country, but states created the federal government. And in our system, they are co-equals, co-sovereigns, except where the supremacy clause comes into place based on those specific enumerated powers. And only then are the states to heal and follow the supremacy clause. Otherwise, there are inherent authority of the states for health and safety and general welfare. The difference is political subdivisions are not co-equals with a state. They are subdivisions. They are created by the state and have limited authority and limited jurisdiction. Specifically in Kansas, the Kansas legislature has codified its intent to designate the attorney general, not local governments, as the representative of the state in statewide litigation. So a specific statutory grant following the common law authority. And our legislature in Kansas has also taken the step to say that state law determines whether local governments are authorized to bring certain matters in what would be representing the state's sovereign interest. And we argue it doesn't exist, and it's only for their local issues that they have that authority. Kansas law is explicit where it says the county's home rule powers are limited to, quote, local affairs and government, end quote, and are always subject to the uniform acts of the legislature. So that's where this, I think it sets the stage for the dichotomy, and where through creative lawyering, if you will, on doctrines that have existed on only local issues and matters under what is public nuisance law, has now seen this explosion and burgeoning of litigation. And that's what we're here to talk about today.
So, Rob, why have these political subdivisions gotten involved in litigation that impacts the entire state? What's the lure for them?
In a word, the lure is money. They're being pitched by contingent-fee plaintiffs firms to bring suits that they're told will return large amounts of money to their budgets with no risk because they're contingent fee arrangements. My kids would probably call it FOMO. So if a municipal official is told that other local governments are bringing public nuisance cases that could produce high dollar returns, they don't want to be left out. And particularly if they don't think there's any cost or risk to them, hey, why not? Now there's history behind this. And this might inform and reinforce sort of the FOMO principle here. Local governments were not involved in the Tobacco Master Settlement Agreement. That was driven by states using their parents' patriae authority. And they weren't involved in the National Mortgage Settlement either that I worked on as an AG for several years. And maybe they felt, well, gee, the states were getting these big payouts, and this, with tobacco, the states continue to receive annual payments from the tobacco companies. It wasn't until opioids that we began to see a really big increase in the number of local governments bringing lawsuits. And I think one of the reasons for that is that the states were already represented. So, for example, the first two states to go out and bring lawsuits using outside counsel were Oklahoma and Ohio. And, there are a limited number of states that are willing to do that, therefore a limited number of potential clients for the contingent fee plaintiffs firms. But there are lots and lots of local governments. So I think we ended up with about 2,700 local governments ranging from hospital districts to cities and counties and others bringing these lawsuits claiming that they needed to be compensated for higher public health costs driven by the opioid epidemic. So that really was where we saw the floodgates opened, and we'll talk about that case today because it really illustrates the severe problems that having thousands of local governments bring their own cases, in addition to cases the states may bring, the problems that can cause.
Thanks, Rob. So as we continue to set the stage here, Andy, what significant concerns arise when state political subdivisions step forward so aggressively in litigation, like Rob was describing?
Yeah, thanks, Glenn. Thanks for having us. And it's a very good question. So there are really a lot of problems, not only for state attorneys general themselves, which is kind of mostly the topic today, but it also harms the courts, industry, and probably most important, interestingly enough, are the people who are actually harmed in some of these cases. So maybe I'll start first with CDAGs. As Joe has really well laid out, it really challenges their parents' patriae authority. As he explained, this is really a standing issue. The state really is the one who has the ultimate authority to represent to represent its constituents, especially these issues that are statewide of importance and effect. It's not the local government purpose, or they don't have standing for the reasons as Joe explained. So not only does it harm the CDGs, second, really it harms the courts as well. When you have thousands of such cases, it clogs up the court system. It forces them to go into to MDLs, which are where all the cases get consolidated, and it's completely unwieldy for the courts and adds extra costs for the parties who are litigating the cases. Thirdly, it really affects industry, those who are targeted as the ones who are often the ones who are targeted in these lawsuits, because they have to defend these cases in multiple jurisdictions throughout the country, and this obviously is very costly and cumbersome for those companies, and it also creates great uncertainty for doing business throughout the country and trying to figure out how to operate their businesses. And then fourth, as I mentioned, and really most importantly, it harms consumers. A prime example of this is the opioids litigation, where there were over 2,000 political subdivisions in that litigation. And there it really prolonged the settlement discussions in many, as much as 2 years. We saw that it delayed settlement discussions because of the attorneys, the plaintiff attorneys in those cases were representing the local jurisdictions. We're all fighting over, not surprisingly, attorney's fees. And this obviously delayed the distribution of dollars to those who really needed it the most. So who are the ones? Those are the losers in all this. As Rob mentioned, the winners in this whole situation are the plaintiff attorneys who walk away with substantial amounts of money in these types of cases. So that's really who it harms. Those are the problems associated with these types of lawsuits.
And if I could just follow on that real quick to amplify what Andy's just said. So not only delayed 2 years in distribution of vital dollars to try and combat the opioid epidemic, to get those monies flowing to the communities that needed them, and to hold companies to account for their alleged misrepresentations that led to the addiction crisis and our opioid crisis. But ultimately, the only thing that changed in those 2 years and the delay that took place was more money went to the attorney fee pool for the municipalities. So the benefit was not there for the public interest, and for the crisis at hand. And so I also want to amplify what Andy says, to protect consumers. That's the other critical issue here, and why attorneys general are the ones situated and best suited to handle these cases of statewide importance, because we look out for the interest of the state as a whole, not one particular county or one particular area of the state. And a county is not suited to represent all those interests, doesn't have the knowledge or information to gather all of what we think is the best interest to resolve this on a statewide basis. Their interest is local, and really their interest is the percentage of the contingency fee after the contingency fee comes out that the lawyers are generating. So the underlying public policy interest here is what is in the best interest of the state, that parent of the country type of sentiment, if you will. That's why this common law doctrine is so important, and it's bolstered by specific statutory authority, consumer protection, and other type of statutes that attorney generals can utilize to look at that overall state interest. And that's why when you piecemeal this, not only is there delay, consumers lose out, and the best interest of the state is not represented.
Thanks for accentuating some of those points, Joe. Andy, just a real quick follow-up. Is it fair to say that the more lawsuits that are filed by local government entities gives credence to legal theories that may not necessarily be all that strong and can sometimes lead to additional litigation filed by individuals using the same sort of theories or at least variants of them.
Yeah, absolutely. I mean, we're seeing the same types of claims brought in these cases. They're largely public nuisance cases, and we can probably have a whole separate webinar on that in itself. But I'll talk about some public nuisance type claims and other cases that we're seeing. But to your point, yes, this is a problem, and when you because they start using these claims like public nuisance that really was supposed to be meant for, in all historical purposes, for property type cases, not for product liability cases. It does cause a problem, and then we can talk about this a little bit more as well. But consumer protection type cases are really meant for statewide cases, not local jurisdictions, and sometimes they bring these UDAP type cases encroaching again on the state AG's authority. So yes, it's a problem for many reasons, but also for expanding these type of legal claims.
Thanks. So Rob, you both you and Andy mentioned the opioid litigation, and in the working paper done by former Attorney General of Nebraska, mentioned that kind of as a case study. Can you get a little bit deeper into that, and how did that set the stage for kind of more of what we're seeing today?
The opioids litigation.
Yes.
Yeah, I mean, it set the stage because for two ways. Number one, because it made it clear to a very large number of plaintiffs' firms that they could go out and recruit all kinds of governments. They didn't have to, win the bidding for the state to be their client. So lots more firms getting involved and just copying each other's complaints. That was really really critical. And secondly, some of the big firms were quoted as saying, "Well, this is the silver bullet. No industry, no company can withstand this onslaught that occurred in the opioids litigation," and that's probably right. I mean, there are a lot of very large companies in this country that are worried about the burgeoning amount of plastics litigation, claiming that plastics are a public nuisance, and going after targets or thinking about going after targets up and down the plastics vertical, from petrochemicals to retail shelves. And as a senior official at one company told me, like we can handle even a bunch of states coming after us if we have to, but thousands of lawsuits brought by local governments, now that's existential for us. So silver bullet theory on the one hand, opportunism by a very large number of law firms on the other hand, explains why opioids became the model, but now we're seeing efforts to replicate in a variety of different kinds of public nuisance claims.
So you just mentioned plastics. In the working paper that you and Andy did, you talked about a couple of examples of where this is beginning to emerge. Plastics was one of them. Can you mention a couple of the other ones?
Sure. One that I'm personally involved with, along with Andy, are the climate change cases. There have been dozens of climate change cases brought by local governments, some by states as well, but quite a few by local governments. And they're all based on the same broad theories of public nuisance, and also importantly, they have been claiming unfair and deceptive acts and practices by the energy companies dating back many, many decades over claims about climate change and about how green those companies are. So that certainly has been highly burdensome. And in some of these cases, you have groups of local governments, coming together and bringing cases within a particular state, like for example, Colorado or Maryland. We also now are seeing these kinds of cases brought on behalf of other kinds of plaintiffs, including Native American tribes. We have one of those in Washington State, in fact, the only one in the country so far that I know of, and even now some wrongful death claims being brought. But most of these cases are being brought on behalf of local governments based on public nuisance theory and a kind of consumer protection theory about whether the energy companies were unfair or deceptive in their claims, and claims about climate change and claims about what they're doing with green energy, for example. PFAS, forever chemicals, is another area where we've seen a lot of litigation involving local governments. That one, at least, you could argue, is closer to the true nature or true purpose of public nuisance. If you have chemicals left in the ground, then it looks more familiar to us than claims about climate claims and claims about plastics recycling. One that Andy will talk about that's newer is the growing trend of bringing claims against manufacturers of foods. And the marketing gimmick here is they call them ultra processed foods. They'll even claim they're not really food. And so these are claims where the public nuisance theory advanced is that public health has been impacted by the consumption of these so-called ultra processed foods. And so that makes these cases sound an awful lot like the opioids cases and the tobacco case. So I know you're going to have Andy talk more about that, but I think that is one of the newest ones, and I think we really bears close attention because the early cases are being brought by municipalities, not by states by and large.
So before we jump into the UPF issues, how do you think the decision by the Maryland Supreme Court is going to play out in other cases and jurisdictions? It's not the first one where a state court has shot down these sorts of theories, right?
Yeah, it's particularly focused on the climate cases, right? It is about the climate cases, and what it's focusing on there is the constitutional argument that not everything can be solved in the courts, and I think that is an important theme to your point, Glenn. One of the things that distinguishes these public nuisance cases from other sort of classic pollution cases, for example, is that they're claiming that we need to address any negative externality created by any product. It's a lawful product, it's a regulated product. They claim a negative externality like plastics waste, and that needs to be solved through the courts. Similarly with climate, but a series of court decisions have come out in federal courts and state courts, most recently Maryland, saying no, the federal government regulates pollution. And climate change is the result of consumption of fossil fuels and other factors. Obviously, making concrete creates greenhouse gases as well, but that's happening globally. So for a state or a local government to claim that the energy companies were responsible for damages in that locality from worldwide activity is beyond what the courts should be asked to address. And of course, pollution is a negative externality. It's appropriately legislated and regulated and has been heavily by the federal government through laws like the Clean Air Act, the Clean Water Act, and so forth. So it's very heartening to see the Maryland Supreme Court uphold the lower courts' respective decisions in that state, striking or tossing out these climate cases. And I do agree with you that some of the language and reasoning in the Maryland Supreme Court's decision will have application in other kinds of public nuisance cases, perhaps including, for example, plastics.
So, Andy, on the issue of ultra processed foods, we already have this lawsuit. The first one was filed on behalf of one person by Morgan & Morgan, but now they're representing the city of San Francisco on that. And there's a lot of discussion, obviously, about the issue of ultra processed foods in the federal government and in the states as well. How do you see these sort of going from this point?
Yeah, as you mentioned, San Francisco is the first city. Now, San Francisco and California is a little unique in that under California law, local jurisdictions can bring consumer protection claims, UDAP claims under their state law. So they're an outlier as we talk about these types of local lawsuit cases. Having said that, the case is really concerning on so many levels and kind of piggybacking up on what Rob is saying on the fact that these are very regulated companies. That's a problem for businesses, obviously, who go through the entire process through this very rigorous process of getting their food, industry standards, highly regulated. And then once they get through the entire process, after all this, after investing all this money, and selling a lawful product, they can then potentially be held liable for billions, millions, if not billions of dollars. So that's obviously very concerning for businesses on so many levels. And then it's the question of what happens from there. If San Francisco is successful, if they find it obviously a decent court that can obviously produce copycat cases, and when you have big law firms that will then go out throughout the country and try to replicate this. And that was really what the fear was with the opioid litigation. That obviously there was a lot going on with the opioids at the time, but the local jurisdictions using that playbook really is concerning, and it's playing out as we thought it would. Pick your next type of product, and this now is ultra processed food, quote unquote ultra processed food is the next target. So yeah, it's very concerning. Where it goes from here, it's hard to say, but I'm guessing plaintiff attorneys are very resourceful, and they will more than likely use this going forward. The other thing I will say, though, this has popped up for the first time. This isn't a partisan issue. This is kind of where the Maha movement a little bit comes full circle, and we've had one case involving artificial dyes with Attorney General Ken Paxton out of Texas. So this isn't necessarily a partisan type issue.
So you could potentially have courts here essentially defining what an ultra processed food is. It's kind of a made up term, really. There haven't been, and I think some states are either have passed laws or pursuing laws to give it a definition. But you can really get down to that level, honestly, right? That courts will determine who's liable or who could be sued based on what their impression of an ultra processed food even is.
Yeah, and the other issue, going back to the legal theories that they're using in these cases, they're not using negligence. They're using these UDAP, unfair, fraudulent, deceptive practice statutes, which have much less of a rigorous standard in court. They don't have to show causation necessarily. So when you're using those types of legal theories, it really opens the door. Now, we're seeing the good climate change decisions on this front, even getting down to the addressing those issues actually on the merits. But yeah, this is concerning on some very many levels.
So Joe, Rob mentioned recyclable plastics, and there's claims that Kansas's Ford County has brought against 11 energy and petrochemical companies. Can you talk about that and what the Attorney General in Kansas has done in response?
Sure. And let me just follow on Andy's point real quick. Nobody's saying that if companies are not acting, under the law or misrepresenting, they shouldn't be held to account. But where if the damages alleged by these municipalities are more global, that is not their role. That is not what we believe they have the authority to do, and they shouldn't be able to speak for the entirety of the state, especially because of the economic impact that has on not good for businesses leaving states if it's not a friendly environment. So that turns to what has happened here in Kansas on two counts. Ford County was pitched a case. Not all of we understand, commissioners in the county that didn't attend that hearing were even aware that it was voted on at the time that it was. But they agreed to bring a case, Rodriguez v. ExxonMobil on plastics. And they filed their initial complaint in Kansas in November of 2024. And they voluntarily dismissed that, and they consolidated it with a consumer class action that had already been filed in the Western District of Missouri. So when Attorney General Kobach found out about that, said this is not correct under the law. They don't have the authority to do this. They don't speak on behalf of all Kansans, especially on the claims that they were bringing in antitrust, some consumer protection type claims, unjust enrichment, and then, of course, the ubiquitous public nuisance. So Attorney General Kobach moved to intervene in February of 2025. The court granted Kansas's motion to intervene, and then it went up to the Eighth Circuit, which issued a writ of mandamus requested and ordered the case to be returned to the District of Kansas. And right now, Kansas and the defendants have moved to dismiss that. And the theories on the motion to dismiss, really boil down to what is standing and who's the real party of interest. Our courts in Bank of Kansas versus Davison have said the real party in interest is the party who, by the substantive law, has the right to seek what should be enforced. Only the real party in interest, and not merely any party who will benefit from an adjudication, is standing. And that's why we argue this global theory of, plastics and the increased costs, and there was these alleged misrepresentations. That doesn't apply to Ford County in particular. What would their specific causation and damages be? If these are general misrepresentations that impacted the state of Kansas as a whole, then that's something that the Attorney General can and would look into and then bring that action on behalf of the state interest. So these generalized claims, these universal claims are improper, and we argue also they don't have that statutory or sovereign authority to bring that in a statewide public interest case. They've also now filed a case, same county, this time in New Mexico, regarding shale oil type claims, and claiming that there was an artificial cabal to fix prices and restrict the production. And they don't bring it in Kansas, they brought it in New Mexico. So what the Attorney General has done there under those same theories has moved to intervene. That action was filed in October, around the same time, 2024. And then Kansas moved to intervene and file a proposed motion to dismiss in April of 2025. The court held a hearing on Kansas's motion to intervene and the request then to file a motion to dismiss. That was July of 2025, and now we sit here almost April of 2026, and we haven't had a ruling on that case or on that motion yet. So this is the kind of the web. This is the explosion of litigation. So we have a county in Kansas who originally filed in one case in Kansas and then dismisses and moves to a neighboring state, Missouri, and then follows with, having this shot by plaintiff's lawyer. Do you think Ford County thought to bring these cases, especially in New Mexico, on their own initiative? Of course not. And even worse than filing in Kansas and then moving it to an adjacent county and then their state and then having that brought back, they file all the way out in the west in New Mexico, claiming to represent the interests of the state. There's 105 counties in Kansas, and there's one attorney general who speaks for those counties and the population in those counties on these themes if they are truly violative of Kansas law on a statewide basis. And that's why General Kobach has found this to be a breach of separation of powers, of statutory authority, of common law doctrine. So he's taken the affirmative action to file in these cases and move from their dismissal. We'll talk about it a little bit more later, but there also needs to be legislative reform, not only in Kansas, but in other states, to combat this growing trend, this problematic trend where they take laws like public nuisance that were never intended for this. These were for local matters of dangers, smell, pollution, noise, a dangerous situation, to remedy that in the locality, not to bring these, let alone statewide claims, but really saying they're representing nationwide classes of government entities. It was never anticipated to do that, and we'll see how these courts react.
In that latter case that you were talking about, Joe, were there other political subdivisions from other states that were involved in that as well, or was it just Ford County that was the plaintiff in that case?
That's a good question. I know that they're proposing to represent all of persons, governmental entities, and non-governmental entities who indirectly purchase crude oil derivative fuel products since 2021. So there are other states implicated in this, but they're trying to speak on behalf of all of them.
So how is it that they ended up in New Mexico? That's really, really puzzling.
That's a good question, and that's one of our arguments. Why there? Where's the standing? And why are they what authority are they claiming to speak on behalf of all of Kansas, let alone all these other governmental entities?
Right. So Andy, circling back to the opioid litigation for a little bit, what did the Ohio Attorney General do in that instance to protect his office's sovereign authority to litigate on the state's behalf?
Yeah, I mean, before I get to that, Joe brings up a really good point. And really the purpose of our white paper that Rob's and my paper it's really meant to do is to provide avenues and things that can be done to fix this problem. So there's really two issues, and Joe just hit on one the two, which is one is state AGs can act themselves, they can intervene in these cases, and I'll talk about what Ohio AG Yost did in the opioids litigation. But two, and we're going to talk about this in a little bit, is legislation. And we'll get to that in a second. But really, there's the purpose of this white paper is to provide a roadmap what can be done. So in Ohio, going back to the opioid litigation, as we talked about, and there was a federal MDL in Ohio. The Attorney General from Ohio, Dave Yost, he brought his case in state court, didn't want to be in federal court. But there were two bellwether cases that were going forward in the MDL in the federal court, and he moved in that case and filed a writ of mandamus, asking the court to either one, stay the case pending the state claims, state cases, or to preclude the federal government from going forward and trying those cases at the federal level. And again, he argued much of similarly what was argued in General Kobach's excellent briefs, arguing the same types of parents patriae authority and the like. Real quickly, though, interesting in that case, there were 13 state AGs in the District of Columbia who filed an amicus brief as a bipartisan amicus brief, actually filed by Michigan Attorney General Dana Nessel. So you got Ohio and Michigan, which normally off the football field, aren't always on the same side of things, but they're in the opposite parties too. She came forward and filed a brief with a bipartisan brief. So this really isn't a bipartisan issue, or isn't a partisan issue. It's a bipartisan issue, a nonpartisan issue, if you will, really affecting all the states.
So we've discussed the litigation side of things, as you've mentioned, Andy. There's some things that can be certainly done from a state legislative perspective. So Texas adopted legislation in 2019 relevant to our discussion. How does that law work, and has it been, do you think, effective in deterring this kind of political subdivision litigation?
Yeah. So Texas, as you mentioned, was the first state to adopt this in 2019. It's House Bill 2826. And it does a number of things. And quite frankly, I'm going to kind of preempt a little bit of what Joe is going to talk about next, because it largely mirrors Kansas's new legislation, which we'll talk about here in a little bit. Mirrors pretty much very similar to what Texas did. So what triggers the law, this is really trying to get at outside contingency fee firms shopping litigation with local jurisdictions. So what the bill does is when a local jurisdiction in the state wants to hire outside private contingency fee counsel, they have to get approval from the Attorney General. There's a whole bunch of processes that they have to go through with holding an open public, have a public hearing on it, all the rest. I don't need to go into that. But before signing the contract, the local government has to get approval from the Texas Attorney General. Without that approval, the contract is invalid, and the outside lawyers can't legally represent the locality under the agreement. What the Attorney General reviews in that process is whether hiring outside contingency fee attorneys or firm is necessary, whether the government lacks sufficient in-house resources, the contract terms are reasonable and not excessive, the contingency fee percentage is appropriate, and the arrangement serves the public interest. It has to serve the public interest. And lastly, the AG can approve, deny the request, or require modifications. I have to be really clear, though, these only involve the type of cases where the local jurisdiction is trying to hire outside contingency fee counsel, where the lawsuit itself has a statewide impact. It's everything that we've talked about up to this point, where these cases really are under the parents patriae authority of the Attorney General. This type of legislation does not affect situations where a local government has to hire an outside firm for some kind of contract issue or something purely local. So this only affects issues of statewide impact. Last year's question, has it been successful? Yes. To date, we have not seen any lawsuits that have been brought or approved by the Texas Attorney General's office using outside contingency fee counsel. Now, there may have been one or two that have slipped past us, but I've done a pretty exhaustive search, and we have not seen any that have been approved.
So if, let's say the city of Austin wants to hire private counsel to file a lawsuit against data center manufacturers or those that own the data centers for public nuisance, that's not the kind of thing that would have to go through that process.
Only anything that's of statewide impact, and anything that would fall under the state's attorney general authority. So anything purely of local concern, they could still hire their own outside contingency fee attorneys.
Joe, can you talk about what the Kansas legislature has been up to in this space?
Sure. So we've got two bills. One is passed out, and we'll go to the governor, see if she will sign it. And if not, if it's vetoed, will be overridden. It follows a similar package last year that they had some retroactivity language in there that was problematic. And so the governor vetoed it. And I think the legislature was out of session at that point, so it couldn't attempt an override. But this year it's House Bill 2593. And it requires, similar to Texas public subdivisions, to hold a public hearing before entering into contingent fee contracts for legal services. And then those are reviewed by the Office of the Attorney General. Certain limited categories are exempt, of course. Those include contracts for bond counsel, debt collection, recovery from an at-fault party's insurer, the sale of property, court trustees handling support orders. But all political subdivisions, including counties, cities, school districts, library districts, hospital districts, community college, would be subject to it as political subdivisions. So following an approval in an open meeting by the political subdivision, they must submit documentation to the Office of Attorney General, including the proposed contract, describing the legal matter, showing us the meeting notice, the agenda materials, and statements supporting the need for that type of contingency contract. They would be submitted to the Attorney General's office. That would be deemed confidential. The AG and the personnel would have 45 days to review, to either approve or deny. And denial would be limited on the grounds of the matter overlaps with litigation already being pursued by the state. It could be denied because the claims are more in line with parents patriae or AG statutory authority and would be more appropriately handled by the state, or for some reason the contract violated the Kansas rules of professional conduct. The Attorney General's office didn't act within 45 days, the contract would be deemed approved. And of course, contracts involving purely local matters would have to be approved, and that means you're just litigating within the bounds of your county, impacting your county, not on a global scale or a statewide scale. And if for some reason a county did not run the contracts by and get the approval within the 45 days, the bill authorizes the Attorney General to intervene and seek dismissal of the case if the political subdivision failed to comply with those requirements. Another piece of litigation that is moving along, it's still in conference and should be dealt with today, because today's probably the last day of regular session, where bills are going to come out, waiting for the veto session to stay in place. So this is probably the make it or not day, and that's Senate Bill 462, and that's a public nuisance reform bill. And it significantly restructures how public nuisance claims can be brought in Kansas, not only by municipalities, but even by the state. And it really is designed to reduce the risk of lawfare, forum shopping, contingency fee shopping done to lawful products and pitched to political subdivisions primarily. So the key provisions of the bill, they clarify what does not constitute a public nuisance, specifically the design, the manufacture, the distribution, sale, labeling, marketing of a lawful product, actions or conditions that are authorized, approved, licensed, or mandated by law, unless there would be negligent conduct involved in that activity, and any aggregation of individual rights or private injuries, including private nuisance claims. Those would not be deemed public nuisance and be allowed to be brought in the state of Kansas moving forward. Now, the political subdivision still could bring public nuisance claims when the alleged nuisance is wholly contained within that jurisdiction. It's an injury like traditionally known of public nuisance laws, odor, contamination, noise, inherent danger, those type of things that needs to be fixed, through the equities of public nuisance type jurisdiction. The matter extends beyond a single jurisdiction, it's between other counties or multiple states, then the Attorney General has the discretion to pursue that claim or authorize the subdivision to proceed if it is truly limited in what they're seeking and not a class action of a statewide or global sort. But the bill does preserve the Attorney General's ability to pursue relief under traditional tort theories, including product liability, but most specifically consumer protection. So it wouldn't limit the Attorney General's ability on that under those laws, because that would be closely scrutinized and given more thought, and not just saying, oh, here's a contingent fee counsel pitch, let's run with it. But public nuisance definition and those reforms would be limiting quite a bit. And maybe, more so than any other place in the nation if it passes. So hopefully will come out today, and we'll see what the governor does. And then we'll see where the separate municipal litigation oversight bill takes place. So again, this is that two-prong approach. I mean, it's kind of a crapshoot sometimes when you try and litigate these things in courts and where they may or may not come out. And that's why, according to the white paper and the forward done by Attorney General Kobach, there has to be this two-prong approach legislatively as well to kind of rein in these novel, overly creative theories that have really run amok. And as I said in the beginning, all that we've talked about today really indicates separation of powers. Where does the authority of the state vis-a-vis the localities come into play? And when those lines are blurred, or where those lines are blatantly crossed over, this is the litigation chaos that ensues, and there are problems downstream, and that's why they're not manageable all the time, as Rob had said, in the courts. That's why there has to be legislative thought to it, public policy thought to it. And so the white paper, General Kobach's leadership in the Ford County cases, and then his leadership in the legislature this session with these reform bills are all the necessary steps to try and rein in what's really been problematic in our court system across the country, really coming out of the opioids litigation of several years ago.
And if I can echo what Joe just said there, Attorney General Kobach really has been a leader on this. He's taken both an active role, as Joe just said, legislatively and through litigation. So, and he's really kind of stepped up and has been the leader right now amongst his peers. So we need to thank Attorney General Kobach and Joe for all their work on this matter.
Thanks, Andy. Just want to remind everyone, if you have a question, you're welcome to ask it using the Q&A function in the Zoom toolbar. Just really a question for any of you. Is there any kind of budgetary related restraints that states can place on what political subdivisions spend on these kinds of lawsuits? I know that obviously contingent fee lawyers go around saying that it's not going to cost them anything, but there still are costs that are undertaken by political subdivisions, legal departments, and whatever. Is that something that's been considered at all, or is that not something that you think would work very well?
I can address that from the perspective of being a former attorney general and a former member of the Metropolitan King County Council in Seattle, one of the largest counties in the country. I would say that mechanism would be challenging to use, but not impossible. Every subdivision of state government, including the counties, and every authorized municipality, like cities, receives some amount of funding from the state government. So there is the power of the purse strings. I don't know that we've really seen that exercised too much yet, but one of the points that the 14 states that filed an amicus brief in support of Ohio in the opioids litigation in 2019 made is that there were huge costs associated with opioids, and that called for a centralized approach to compensation for those costs. So that emphasizes really, as Andy's already mentioned, the truly bipartisan nature of this concern that AGs have from states as diverse as Michigan and Texas, Hawaii and South Dakota, and many others besides. They all believe that it's within the authority of the states, and I'm quoting from the amicus brief, to manage litigation that will affect the entire state and to enter into binding agreements that will make all of its residents whole. So with enough will, certainly a governor and a legislature could put considerable pressure on municipalities to, not mess it up, right, through their own individualized litigation. And that would include some power they have over funding for services such as, healthcare and, public health, community health clinics and the like.
And if I could add to that, I probably there's a mechanism. I agree it would be challenged. I'm sure courts would be more sympathetic to that challenge versus just a straight on policy decision of limiting what kind of cases they can bring, what kind of contracts they can enter into, especially with review on these contingency contracts. So, the political subdivisions have strong lobbies, so that can't be underestimated either. And when you talk about funding that could impact other services within these political subdivisions, I think that's probably a political battle states would be losing from the PR perspective, as well as just the nuts and bolts politics of it. But when we're talking about limiting plaintiffs' lawyers and their shopping of contingent fee contracts, when there's no supervision of those, especially as the issues that really don't have a direct impact on those localities under state interest, that's where I think we have the high ground. And people are more receptive to that and they understand that. So I would say attack the issue head on, because the other one is probably a two-front war, and we have enough wars going on right now. We don't need another one that would be very murky.
Thanks, Joe. So, Rob, what can businesses that have become targets of these kinds of political subdivisions lawsuits do where the state attorney general and or the legislature have not previously faced this situation? If it's something that's relatively new to that particular state or with those political subdivisions, how can they get in sort of on the ground floor of working with people within the state to help push back against this?
Well, it's very important for businesses that find themselves in that situation to engage. And it's important to have national organizations like the U.S. Chamber of Commerce be involved. It's also important for statewide organizations. Most states have a state chamber of commerce that is a coalition of companies and coordinates with local chambers of commerce. So they need to any business or set of businesses that are being threatened by this problem of municipality litigation encouraged by contingent fee plaintiffs firms. They need to get in front of the governor, in front of legislators, and critically in front of the attorney general to explain the problem and to encourage the state AG to rein in that kind of litigation, to take the brave steps that Attorney General Kobach has taken, and we've talked about, for example, by intervening, and also by supporting legislation that will regulate the use of contingent fee contracts that municipalities otherwise might enter into with very little public scrutiny or awareness, as we saw with Ford County, where the public there, and most of the rest of the Ford County government did not even know they had done this, that the commissioners had signed this contract with the plaintiffs firm. So engage, educate, communicate, and if you're dealing with an AG who wasn't around for the opioids litigation, inform them that this is a concern that AGs from states ranging from Hawaii to Michigan to Texas, many others besides, have actively engaged on and have taken a strong position on. As a former AG, I'll tell you, we would have been hard pressed to have achieved the Tobacco Master Settlement Agreement, the National Mortgage Settlement, and other important settlements if we had been faced with thousands of individual municipal lawsuits, which is exactly why the state of Ohio filed a writ of mandamus with the federal court, which was supported by those 14 states. There's just an awful lot at stake. Joe did a great job of explaining what was at stake there, not just in terms of the law and the legal rulings that would come out, but also in terms of great delays for improvements to public health and consumer welfare because of the multiplicity of very expensive litigation. So there's a lot at stake, but don't assume policymakers already know that. Don't assume they're even aware that these municipal lawsuits are being brought. You have to engage and leverage all the coalitions at your disposal, including your state chamber of commerce, to make sure that policymakers are aware and are going to take action.
Andy, any thoughts on that?
No, I think Rob summed up really well. This is obviously a hugely important topic. It's one that's was just actually spoken about at the NAG National Conference back in December. State AGs this is a top of mind for them. It continues to be. It's an issue that's not going away. So stay tuned. That's why I think this paper and this webinar are so important.
Probably my favorite acronym of many, many acronyms that I deal with regularly is NAG, the National Association of Attorneys General. For those of you not familiar with that. Well, I want to thank everybody for joining us today. And Joe, Rob, and Andy, thanks for doing such a great job of laying everything out. For those of you who are interested in the working papers that we've been mentioning during the program, I will put links to those on the program page. So we record this, we'll put it up as a recording on our website, and we'll send around an email to everybody who tuned in so they can get to that. So we'll include those. Please do share those working papers with others that you think need to be educated on these issues. I think they do a very good job, both the first one we did and the one that Andy and Rob wrote that Attorney General Kobach did a forward to. Obviously, I think that as the publisher of that they did a very good job. But I think we've heard from others that it's been they've been really good resources for people to learn about this and figure out what can be done to this increasingly difficult problem. Thank you again for all of you for joining us. If you have a few seconds after the sign off, there's a survey of 4 or 5 quick questions to answer. If you could do that, we really appreciate it. And again, Andy, Joe, Rob, thanks so much for joining us today.
Thank you.
Thank you. Have a great day.